Good afternoon. Welcome to our webinar, a joint collaboration between SCOTUS blog, which stands for Supreme Court of the United States blog, a website that covers the Supreme Court, and Street Law. My name is Amy Howe. I'm a reporter for SCOTUS blog, and I'm joined today by Cathy Ruffing, who's a senior director at Street Law, which is an organization that helps to teach people about the law and their rights. Cathy is a senior director at Street Law, but before that, she taught AP Government in Fairfax County, Virginia for 27 years. Cathy, thanks for joining us.
Hi. Hey, everybody. Thanks for coming. We're happy that you joined us today, and we'd like to start out by finding a little bit about who is here with us. So we're going to have a poll pop up in a moment, and if you would take the poll, let us know who you are. We'll give you about 30 seconds maybe to do that. And then we'll move on to start talking about how to participate in the webinar. Okay, you should see the poll now. So find the one that is most closely aligned to who you are. And if you're none of those things, there is an other at the bottom. So feel free. Okay, can we see the results of the poll, Cal? Okay, great. So I noticed that some of you are high school teachers or other teachers. So I will at some point put my email in the chat so that you can feel free to contact me if you want teaching materials about this or even this PowerPoint. Be happy to send that. Okay.
So if you're not a teacher or a student, we're glad you're here too.
So how to participate in the webinar, no matter who you are. If you would like to leave questions, there's two ways to do that, but we would prefer that you use the Q&A. So if you have on your toolbar the Q&A, you can leave your questions there. And it's great if you could read the other questions first. And if someone's left a very similar question, you can just upvote that question. And you can also, if you have a sort of an add-on to that question, you can comment with a follow-up, and that'll let us see where the most interest is so we can answer. The Electoral College, because both of our cases that we're going to talk about today, Chiafalo v. Washington and Colorado v. Baca, both have to do with the Electoral College. So first of all, we know that the framers of the Constitution, they wanted to set up an indirect election of the president. So they set up this Electoral College system. So in the summer before the election, months before the election, both parties select electors. And in the Constitution, it doesn't say much about the Electoral College and the selection of electors, but it does say that states get to appoint those electors. So I'm going to use the example of Washington State, since one of our cases has to do with Washington State. So we'll kind of kill two birds with one stone there. So in the summer, the Democratic Party in Washington would select 12 Democratic electors, and the Republican Party would select 12 Republican electors. Why 12? Because each state has the number of electors as it has representatives in Congress. So each state has 2 senators, and then Washington State has 10 representatives. In Washington State, like in many states, those electors say an oath, and they swear an oath that they're going to vote for the person who wins the general election in their state when it comes time to go to the Electoral College. And they know when they swear that oath that if they break it in Washington State, that they will have to pay a fine of $1,000. It varies from state to state, what they do as far as having them do a pledge, what the penalty is if they don't vote the way that they say they'll vote. So months go past after the electors are appointed by the state, and we have the general election, and the citizens go to the poll and they vote for their choice. So in 2016, they had the choice of Hillary Clinton or Donald Trump. So in Washington State, Hillary Clinton won, and Tim Kaine, as vice president, won that election 54.4%. So most states, all states except for two, Maine and Nebraska, we have what's called the winner-take-all system. So all 12 of the electors in Washington state would go to, in this case, Hillary Clinton and Tim Kaine for president. That's the way it's supposed to work. So usually by the end of the night in November, the first Tuesday after the first Monday in November, we know who the president's going to be. We count up all those electoral votes when we know who wins. So we don't really know who wins, though, until after the Electoral College has voted and been counted. So in December, those electors go to their state capitals, in this case, Olympia, Washington, and they vote for the person usually who won in their state. So we would have expected these 12 electors to vote for Hillary Clinton. However, 3 of them, the purple ones right there that you see, including the person this case is named after, Mr. Chiafalo, voted for Colin Powell for president, and 3 separate people for vice president. So here's a little bit of trivia that Colin Powell is now the first African-American to ever receive an electoral vote. And so they seal those votes in envelopes, they mail them to Washington, D.C. And in this case, because they said an oath, they knew they were going to be fined. And they were fined by the Secretary of State for Washington $1,000, those 3 petitioners. Petitioners are the people who bring the case to the Supreme Court. So those votes went to Washington, and in January, we count those votes. If one candidate receives 270 electoral votes, that person wins and becomes president. So what those 3 electors were doing is they were hoping that by getting other electors to join them, they would make it so that Trump would not win the 270 electoral votes, and therefore the election would be pushed to the House of Representatives, which the Constitution stipulates is a backup. And in that election, it would be every state would get just 1 vote. And they were hoping that they would be able to change the outcome of the election. So you can see from this graphic that Trump got well over the 270 electoral votes and did become president. So their plan didn't work. But you can also see those ones in the far right-hand corner. Those are other electors who did join our 3 people in this case. One of them will be the respondent in the other case, Mr. Baca. And those people voted for someone else. It's not the first time in history. In fact, we'll hear later that it happened often, but it brings the question up, do those electors have the right to vote for someone, a candidate of their choice, or are they obligated, can the state obligate them to vote for the person who won at the state level? So like I said before, in the Constitution itself, there really isn't a lot about it. So what we often do is we look to the words of the framers to decide what did they mean when they wrote the Constitution. So in this case, we have 2 very famous framers with 2 very different answers to the question, what should the electors do? One is Alexander Hamilton of musical fame, and the other one is James Madison, who is nicknamed the father of the Constitution. So Hamilton, if we look to him for our answer about whether the electors have the right to vote the way they want to, he would say, yes, they are independent. They should have the final say. They would say that the electors are most capable of analyzing the qualities required to be a good president. So he would find for our electors. However, James Madison, who, since he's got the nickname father of the Constitution, holds some weight in this debate, says that the electors should reflect what the people want and that the president should be the choice of the people at large. So when we can't decide, when there doesn't seem to be a solid answer in the Constitution we can put our finger on, when we can't look to the framers and find a definitive answer, those are the kinds of issues that often end up at the Supreme Court, like the 2 cases that are going to be argued on Wednesday, both on the same day. And so the Supreme Court will have to help decide what the framers and the Constitution really meant. So Amy's going to tell us a little bit about those 2 cases and the facts involved in the 2 cases we'll be hearing on Wednesday.
And I should say that the justices of the Supreme Court don't always agree about what the Supreme Court should do when it's not clear from the Constitution what the answer is. There are some justices who say we should look at what the text of the Constitution says and draw the best conclusion that we can. Other justices might say we should try to figure out what the people who wrote the Constitution would have wanted us to do, even if they hadn't necessarily thought of this problem 200 some odd years ago. So you should listen for that debate sort of between the lines when the justices hear oral argument on Wednesday. So these are the three what we call faithless electors, which sounds very dramatic, which is just the term that's used to describe these presidential electors who, when it comes time to vote, don't vote for the people they promised to vote for. So you have Levi Guerra, Bet Chiafalo, who's the name you'll probably hear most often because his name comes first, and Esther John. We're going to talk a little bit about each of the cases. And so one of the cases, as Cathy said, is from the state of Washington with these three faithless electors. They were nominated to serve in 2016. Hillary Clinton won the popular vote. They voted for General and Secretary of State Colin Powell instead, and then they were fined $1,000 each. There's another case from the state of Colorado also with three people, Michael Baca, Polly Baca, who's apparently not directly related to Michael Baca, even though they have the same last name, and Robert Nemenich. They were nominated to serve as electors for the Democratic Party in Colorado in 2016. Hillary Clinton also won the popular vote there. Things played out a little bit differently. Michael Baca, when it came time for him to vote, tried to cross out Hillary Clinton's name and vote for John Kasich, who's the Republican governor of Ohio. But when the officials in Colorado found out that that was what he was trying to do, they removed him as an elector and replaced him with someone who voted for Hillary Clinton. Polly Baca and Robert Nemenich wanted to vote for someone other than Clinton, but they went ahead and voted for Clinton instead when they saw what was going to happen with Michael Baca. So this sort of gives you an idea of exactly what's going on when you go to cast your vote for president. On the one hand, you've got the boxes that you check that vote for either Hillary Clinton and Tim Kaine, who ran on the Democratic ticket, or Donald Trump and Mike Pence, who voted on the Republican ticket. So you think you're voting for one of them, but you're actually voting for the presidential electors who are then going to go to the state capitol and vote for one of those sort of on your behalf. A little bit about how cases get to the Supreme Court. And this is helpful because each of these cases came up on one side of the chart. The case coming from Colorado went through the left side of the court. They started out in a federal trial court, and these are the kinds that you see when you're on TV, what we think of as the same places where they have criminal trials, except in this case, there's not a jury, there's just a judge. But a single judge decides whether or not these laws, they call them faithless elector laws, that prohibit people from voting for who they want to rather than who they promise to vote for, violate the Constitution. The argument is that it violates their right to cast a free vote for whoever they want. And then to the US Court of Appeals for the 10th Circuit, which is an appeals court between the trial court and the Supreme Court, where three judges would have heard an oral argument. And in that case, that court decided that Colorado's faithless elector law did violate the Constitution. On the other side, getting to the Supreme Court, the faithless electors would have started out in a state trial court. And can you go ahead and go to that next slide? Is there a next slide? Yes, so Chiafalo would have gone to first to an administrative judge, then to a state trial court, and then to a Washington Supreme Court. And if you're really interested, you can actually watch a video of that Washington Supreme Court argument. And the Washington Supreme Court, by a vote of 8-1, agreed with the state of Washington that fining Chiafalo and the others $1,000 for not voting for Hillary Clinton didn't violate the Constitution. So then on the one hand, the state of Colorado, and on the other hand, Chiafalo and the other electors both went to the Supreme Court at the same time, actually represented by the same lawyers. And Each side said, you need to go ahead and decide this issue now, justices of the Supreme Court, because this is a really important issue, and you need to figure out whether or not electors have to cast a vote for the people that they pledged to cast a vote for now, rather than waiting for a presidential election, because you don't want to be deciding this in the middle of a presidential election when it could actually make a difference. And your answer about whether or not faithless electors are allowed to do this could decide whether Donald Trump, just to give you an example, if this were to happen in the 2020 election, whether Donald Trump or Joe Biden were to win the election, for example.
Okay, great. So on Wednesday, we're going to hear those two cases, and it's very historic and unique for these May arguments. Of course, the Supreme Court, like most of the rest of America, shut down in mid-March in response to the COVID-19 pandemic. And so they were completely shut down for a while, and then they decided when they realized they wouldn't be opening up this term, that they wanted to hear 10 more cases, an interesting array of cases. And like most cases that they chose, this case has some kind of time sensitivity to it. So Amy just explained that it could have serious repercussions on the 2020 election. So that's probably why they chose these two cases. In these live broadcasts, which until this May had never been done before, and over the phone, so there's the SCOTUS blog banner, which is truly fantastic with all the different justices and their different types of telephones. The attorneys will have 2 minutes where they don't have any questions asked. And that is a new rule that the Supreme Court imposed upon itself this term, that they were using in live oral arguments when they remembered as well. And then they're extending that to the phone calls. This is new for the phone calls, though. Chief Justice John Roberts is calling on the justices in order of seniority. So normally it's just whoever can sort of insert themselves into the conversation, get their question asked. And there are some usual suspects to be first or to ask more questions. But now it's a very orderly line of seniority, and he just calls on justices. So we've been hearing, for instance, more from Clarence Thomas than we normally hear from him, maybe because he's being called upon. Like the live oral arguments, both sides have 30 minutes, including the questions and answers. So they get their 2 minutes in, and then it's sort of who knows after that how much they'll actually be able to speak. A couple of these arguments have gone a little bit over, but Chiafalo and Baca. We think they're going to say that the framers set up an indirect election for president, the Electoral College system, and that they also gave people the freedom of speech. And because of that, the justices should see that they expected the electors to have discretion or choice when casting their ballot. We think they're going to also argue that the Constitution gives the states the power to appoint, but that's very different than the power to control. So once they appoint those electors, they have discretion in how they actually vote. And we think one of the things they'll probably use as evidence of that is that in our over 200-year history, there have been almost 200 electoral votes cast contrary to the state, and that's never been an issue. They've always been accepted as valid votes in the Electoral College. And if there had been an issue with electors having discretion, it should have come up more directly before now.
These are some of the arguments you're likely to hear from the states on Wednesday, and the states will be represented by two different lawyers. One is the Attorney General of Colorado, the state's top lawyer, and the other is what's known as the Solicitor General of Washington, who's the state's top lawyer in court. In essence, his job is to go to court and argue on behalf of the state of Washington. And so one of the arguments is that the Constitution gives the states the powers to appoint electors. And even if it doesn't say so specifically, that really has to include the power to remove or to impose a fine on electors who break their promise, because otherwise the power to appoint them really would be kind of meaningless. The second argument is that the framers didn't argue that the electors should have free will to ignore what the states, the vote of the people in those states. And the final argument that you're likely to hear, and I think that this is an important one that they're really likely to emphasize, is that if electors can ignore the popular vote in their states and break their pledges, then the elections for the presidency, the most powerful office in the government, are really hollow exercises. Everyone thinks they're going to have these campaigns, and everyone thinks they're going to go to the ballot box or vote by mail, whatever it is people are going to do this fall, for example, and cast a vote either for Donald Trump or for Joe Biden. But it's really going to come down to just what these 500 people want to do when push comes to shove.
Good. So we're ready for questions now. So if you have, we have one question in the chat. And that question is, that question is, why don't the electors vote the way the people as a whole voted? Amy, do you want to take that one?
I think Cathy mentioned that, for example, in this case, I think there can be a variety of different reasons, and I think they can be personal reasons. In this case, it wasn't that necessarily that the people who broke their pledge to vote for Hillary Clinton didn't like Hillary Clinton, but they were hoping to do something bigger. They probably really liked Hillary Clinton and wanted her to be president rather than Donald Trump. And then they were hoping by voting for someone else. And so Colin Powell, many of you may not be old enough to remember him. Colin Powell was the Secretary of State in the George W. Bush administration. John Kasich was someone who was the Republican governor for Ohio and ran for president in 2016. I think they were probably hoping that by voting for other Republicans, they might inspire some other electors to break their promises and vote for other Republicans other than Donald Trump, and therefore influence the outcome of the election. You can imagine some other scenarios in which people might want to not follow the vote of the popular vote and break their promise. If some, for example, if some information became evident after the election that might influence how people might have voted, people might decide to break their pledges and vote for someone else. I think there could be a variety of reasons, many of which may be personal, but it's certainly an interesting question. And I think that the justices will probably be asking questions about how the system would operate if they were to rule that electors have no obligation to follow the popular vote. I think it's a great question.
So the other question in the Q&A, which Amy sort of started to answer at the end of that one, is how is it possible for SCOTUS to vote in favor of the faithless electors? Chaos would result. And they probably are thinking about the implications of their decisions. But one thing, and I'll throw it back to Amy for an answer to that question as well. But let me say first, it is possible that they fine for the faithless electors in one case and for the state in the other case, because we are talking about two different issues. One is a fine imposed on
Did we lose Cathy?
Sorry, I froze there. Amy, did you finish the sentence?
No, sorry. I couldn't tell whether you were frozen or not.
Yeah, no, so I apologize to everyone. So it's possible in this case that the Supreme Court could fine for one set of electors and one of the states, because we're dealing with two different topics. One is a fine, which allows the electors to vote the way that they wish as long as they're willing to pay the fine. And that was part of the oral arguments at the state level. It was part of what they talked about. and one is removal. In Colorado, they're actually removed. So they may not find for both sets of electors or for both states. It could be a split decision.
We've got two questions that I think sort of actually can answer with one stone, so to speak. The one question is sort of, how do you think people who focus on the text of the Constitution would vote? And then another question is, if electors can't vote for whoever they want, what is the actual function of the Constitution? If the electors aren't free, then the Electoral College serves no function. And I think that what maybe one thing that what we call, sort of originalists or strict constructionists, which sometimes, but not always, aligns with some of the court's more conservative justices, the justices who believe that you should look very closely at the text of the Constitution, rather than some of the justices who think you should look at what the framers, the founders of the Constitution might have intended, how the Constitution might have evolved. And I think they may say, this is how the Constitution, so there may be some justices who say, this is how the Constitution was drafted. This is what our founding fathers believed the system should be. And perhaps if the system, were to function, there is the opportunity for chaos, but we haven't had chaos so far. And certainly if people are really concerned that there could be chaos, we can change the Constitution, but our job is not to change the Constitution ourselves, but instead to follow the Constitution the way it's written. That's not how I'm saying I would personally interpret it, because that's not my job as a reporter, but I'm saying that could well be an argument that could be very persuasive to some of the more conservative justices.
So one of the questions was, who is the petitioner and who is the respondent? And we have been sometimes in our presentation today talking about the electors in the states for clarity, because they switch roles in the two cases. So in Chiafalo v. Washington, Chiafalo and the other two electors are the petitioners. So they lost at the lower level, at the Court of Appeals level. And so they're bringing this case to the Supreme Court, which makes the state of Washington the respondent. They prevailed at the lower court. In the other case, it's exactly the opposite. So Colorado lost in the lower court at the state Supreme Court. So they're appealing the case to the US Supreme Court, and Baca and the other two electors lost at the lower, or won at the lower level. So they would like to keep the lower court decision. So one of the reasons we haven't been using the word petitioner or respondent much is because since these cases are circuit splits, one of the lower cases, the electors won, and at one of the lower cases, the states won.
We have another great question. If the court sides with faithless electors in both cases, is this potentially the start of revising or replacing the Electoral College? I think the key word there is potentially. I think that if the court were to side with the faithless electors, I think it would certainly be something that there might be a movement to do. I think amending the Constitution is a very, very difficult thing to do. The efforts to amend the Constitution to add an equal rights amendment for women, for example, were never successful. It's been many, many years since there was an amendment to the Constitution. So I think it's very possible that there would be a movement to try to do it. I just don't know whether it would be able to succeed because it's so difficult to do. It's also the kind of thing where it depends on who regards it as an advantage. After the 2016 election, in which Hillary Clinton won the popular vote, but Donald Trump won the Electoral College, there was a movement to get rid of the Electoral College among people who would have preferred to have Hillary Clinton win. I think it's one of those things where sometimes people don't always view things necessarily based on sort of their fundamentals of whether or not they think it's a good idea, but because they are more outcome driven. And so if the shoe were on the other foot, so to speak, and Donald Trump had won the popular vote and Hillary Clinton had won the Electoral College and became president, people might view things differently, is all I'm trying to say. So we'll see.
So we're just about out of time, but we would be interested in you taking one final poll. And we know you don't have all the information yet. The Supreme Court hasn't done their oral arguments yet, but we'd like to know how you think they will decide. So a poll should pop up any moment asking you that. We didn't give the option to split the two cases. So we just have the poll, do you think the Supreme Court should decide for the electors or the states? And notice it says should, not will. So we're not asking you to predict how the 9 specific justices you see pictured there behind you would vote, how you think they should vote with this limited amount of information. We give you a couple seconds to decide that. Okay, make your final decisions and then we'll see what the results are. Oh, wow, that's a pretty
Interesting
split. Great. Well, you know, we might find out in several months. So, and we'll be interested if you are going to join us again.
We'll have to see how whether that changes after the oral argument. Speaking of oral arguments, so the oral arguments are next Wednesday at 10. They start at 10 a.m. Eastern. In theory, the Chiafalo, the Washington case, starts at 10 a.m. Eastern, followed by the Colorado case at 11 a.m. Eastern. The telephone oral arguments have been running a little bit long, so they may not start promptly at 11 a.m. Eastern and be over promptly by noon, but it should be a lot of fun. And then on Friday, May 15th, we will be back here for a post-argument webinar at 12 p.m. Eastern. So thanks so much for joining us. We hope we will see you then.
Thank you.